Hi everyone, our video today is on the protection of copyright works in Asia. We have speakers across 4 jurisdictions here today. We have Vision from Liuming International in China, Mohit from Universal Legal in India, Shamesh from Jeeva Partnership in Malaysia, and Renee from Alpha and Omega Law Corporation, Singapore. Thank you.
Now, China is a party to the Berne Convention for the Protection of Literary and Artistic Works. So copyright is protected under the Berne Convention and the Chinese copyright law and its regulations. So I think probably for this question, we're talking about 2 points. One is whose work will be protected. In China, it's 2 types. One is the works of the Chinese nationals, Chinese legal persons, and organizations. Whether their works are published or not, their work will be protected. Another one is the work of the non-Chinese nationals and stateless persons. The condition is if there's agreements between China and their home country or country of habitual residence, or both China and that country belong to the same international convention, such as the Berne Convention, then they can be protected. It is not a requirement that you must register copyright in China for you to be protected, and which is quite different from trademark law as we discussed last time. Now, second question is, what type of work which can be protected in China? Basically, there are 2 important ingredients when we talk about copyright protection. One is originality, and the other one is whether it's capable of reproduction in certain tangible forms. More specifically, under the Chinese law, works created in domain of literature, art, national sciences, social sciences, engineering or technology, and they created in any of the 8 forms listed in Chinese law can be protected. So I'm just running through the list very quickly. It's an inclusive list, not exhaustive. The first one is writings, such as the novels or poems and something like that. Second one is audio works. Third one is musical works, dramatic works, or choreographic works. And the next one is fine arts and architecture. The next one is photographic works, and then cinematographic works. And then next one's engineering, designing plans, production, designing drawings, or something like that. And computer software. And under Chinese law, is always a catch-all provision which says, or any other works which are provided by law and regulations. Now, applied art is not particularly listed or defined in the copyright law, but because it's covered by the Berne Convention, so it's protected in China. In practice, the general view of the court is it is covered by the work of fine art under the copyright law. And because this is a requirement that it should have the relative high level of aesthetic value, and was quite difficult to establish. Now I ran quickly about the durational protection. The general rule is for the right of publication and economic rights of the author is life plus 50 years after the death of the person. Of course, there are exceptions to the general rules. For audiovisual works, the protection term is 50 years after they're made available to the public or from the creation of the work. For applied art, is 25 years from the creation of the work.
In Malaysia, similarly in China, just like in China, the regulation in 1990 gave or subscribed or recognition to the Berne Convention. In Malaysia, a qualified person, being a Malaysian or body corporate incorporated in Malaysia, can register a copyright. We have a voluntary notification copyright system wherein an applicant can register a copyright with the controller, a part of the Malaysian Intellectual Property Office. Similarly to many parts of the world, The works eligible for copyright is provided in Section 7 of the Copyright Act, which are literal works, musical works, artistic works, films, sound recording, broadcasts, and so forth. Non-exhaustive list. There always been a debate between copyright and design works. Common law, our courts have developed extensively what is eligible for copyrights. It's always a thin line between copyright and design works. And at the end of the day, it depends on the facts of the matter.
So, a common misconception in India is that copyright exists in the idea alone. Now, there is no copyright in an idea, a procedure, or a business method. In India, copyright exists not in the idea, but the way in which the idea is expressed. It is important to understand that when we use the word copyright, it comes into existence on the creation of a work. Now, coming to what is a work. Broadly speaking, a work could be either a literary work, which is a script or a screenplay, a work of fiction or non-fiction, a musical composition, which could be an original soundtrack, an artistic work, which could be a painting or an architectural design, or a software program, where the copyright lies in the way in which the source code is expressed. Now, works are registered in India usually for evidentiary purposes, that is, to establish the date of creation or existence. And unlike in the case of a trademark that we discussed a few weeks ago, copyrighting a work does not offer any right of prior use. The right for action against infringement does not become stronger just by virtue of registering the work. So the best example of when an author should not consider registering copyright would be in the case of a software program or source code. This is largely because of confidentiality concerns, where once you file your source code before the Copyright Office, it essentially becomes a public document which is open to scrutiny. Usually we advise clients that whenever you are looking for private equity investment or venture cap investment or any kind of investment in your business, and your business comprises of intellectual property, including copyright, it would make sense to go in for a copyright registration because there is value ascribed to registration, that is when you go for that kind of thing.
So in Singapore, it's very similar to China and Malaysia in the sense that works of foreigners as well as Singaporeans are protected under Singapore laws. So what are these works that can be protected under copyright in Singapore? It would be literary, dramatic, musical and artistic works, as well as films, sound recordings, broadcasts, cable programs and published editions of them. So generally, copyright protects the expression of ideas. Example, what you've put in words and illustrations. And of course, there are lots of examples of this. For example, literary works would be like your written books, your articles, your lyrics and songs. And musical works would be the melody. Artistic works, your paintings, your photographs, buildings or models of buildings. So these are things that my colleagues Shamesh, Mohit and Vishen have gone through as well. I think it's also good to look at what will not be protected by copyright, since it's such a broad area of what will be protected by copyright. So what is not protected by copyright, at least in Singapore? So subject matter that will not be protected by copyright includes ideas. So like for example, new business ideas that has not been documented. This cannot be protected by copyright. Similarly, concepts. So an example would be a new game show that has not been written down. Then discoveries, research findings that has not been known before. Procedures, steps involved when applying for a travel visa, for example. Methods, unique solutions to a mathematical problem. And any subject matter that has not been made tangible in a recording or in writing. For example, a speech, so an off-the-cuff speech, or a dance that has not been written or recorded. So all this will not be protected by copyright. And also a subject matter which is not of original authorship, meaning the works which contain information in public domain, such as standards and the like. So this is what I would like to share for the first question on what can be protected. Thank you.
The main legal system in China is the copyright law and the unfair competition law, which I mentioned briefly during the sessions on trademark law. And of course, there's the Berne Convention. Under the Chinese copyright law, it listed 16 rights which are given to the copyright owners. And the first one, sort of the law divided into two halves. One's moral rights, another one's economic rights. The moral rights are the right of publication, right of authorship, right of modification, and right of integrity. And economic rights, there are 12 altogether, plus a catch-all of all other rights. The first one is the right of reproduction, and then the right of distribution, right of rental, right of exhibition, right of performance, right of projection, and the right of broadcast, right of internet broadcast, and cinematization, right of adoption, and translation, and the last one is the right of compilation. So it's quite broad. Usually only the economic rights can be transferred, but not the moral rights. But there's one main exception in law, which is the work for hire. When we talk about work for hire, there are two situations. One is the work created during the employment period, another one is commission work. So when we talk about employment, the law says that if you're caught under two situations, any of the two situations, then the work will belong to the employer, unless the ownership, but the authorship will still be retained by the employee. Now, the two situations is, one is the work created during employment, and it's mainly use the resources of the employer, and also the employer is responsible for this work. And the law gave examples, things like the engineering design plans, production design, drawings, and computer software. The second situation, the law says that according to law or the contract. So in that sense, the contract itself is really important. So if you draft in a very general term, by the end of the day, probably the employer wouldn't have all the rights which they should have in the first place. Like I mentioned before, the right of authorship can't be transferred to the employer. For commissioned work, the ownership of copyright can be agreed by the parties in the contract, but whether the parties can agree on the moral rights, that's really not 100% settled under law. So the general rule is, if the contract doesn't specifically say who will retain the copyright, or there's no contract at all, and then the copyright will belong to the commissioned party. So again, it's really important to include appropriate wording in the contract. So it's very important, again, to seek professional advice in this regard. The last one is the unfair competition law, which is really a very broad law, give a lot of protection to people, not just the copyright infringement. So you can rely on that law when you seek protection against law. The law basically says that a business operator can't use a logo identical or similar to the packaging or decoration of the well-known products of another person without the authorization from that person. So the key here is to prove the products are well-known, which can be a little bit challenging.
Yeah, in Malaysia, we have generally three pieces of law. There's the Copyright Act, of course, Berne Convention, as I've mentioned earlier, and we also have the Competition Act 2010. Now, as far as protection is concerned, of course, it gives a copyright owner, if there is, he intends to, of course, protect his rights, he has to ensure that, first of all, the terms that especially a body corporate who wants to protect the copyright, the terms must be clear in the contract. What I find from my litigation experience is that some of the copyright owner, especially a body corporate, they cannot even prove that the applicant or the artwork was produced by their employee at that point of time. Because often than not, sometimes employers, they employ third-party consultants or designers to come up with some kind of copyright for their artwork of their products. So I think they have to ensure that there are clear terms in the contract to ensure they qualify for protection. Of course, there are specific provisions in the Act which gives qualification for protection. The Competition Act, basically the courts have said that a copyright owner should not have a dominant position. They cannot have a dominant position because it would offend the Competition Act. The Berne Convention, I would not want to repeat. It's been recognized by the regulation, and you can seek protection pursuant to it.
In India, the principal legislation for protection of an original work is the Copyright Act, and the authority is the Copyright Office that is headed by the Registrar of Copyrights. The prime function of the Registrar of Copyrights is to rectify errors in the register, to resolve disputes relating to ownership of copyright, and they also have the power to grant compulsory licenses. As far as international treaties are concerned, India is a signatory to the Berne Convention for the protection of literary and artistic work, the Universal Copyright Convention, and most importantly, the trade-related aspects of intellectual property right under the auspices of the World Trade Organization. All these conventions are founded on the principle that original creativity, which are covered under copyright law, should be distributed regardless of national borders. In the case of infringement, a copyright owner can approach any court of civil jurisdiction for an enforcement claim. So, for instance, if there is infringement of a copyright of an original script or music soundtrack, an infringement suit can be filed by the owner before a civil court. Typically, all IP infringement matters go to a high court. A suit for infringement can be filed and an injunction application can be moved within a few weeks. Usually at an interim stage, things get disposed of fairly quickly in India. An important concept in copyright creation also is the work for hire principle. So take the example of a cinema film where you have different components of IP, which could be either the music composition or the screenplay or the script. Now the screenplay writer or the script writer is usually the first author of the work, and so is the music composer. But the owner of this IP is the producer of the film, who essentially buys the rights from the author and combines it to make what is the final film. Under Indian law, authors are entitled to payment of royalty for work. And we also have the concept of copyright societies, which are essentially royalty collection aggregators that are set up under the Copyright Act and are required to administer, track, collect, and distribute royalty that is accrued from the exploitation of IP.
So in Singapore, it's actually very neat. For Singapore works to be protected in Singapore, we have the Copyright Act, the Singapore Copyright Act. And that provides how all copyright works are to be protected, when is it being infringed, what are the defenses against infringement, and things like that. Okay, then when it comes to works by non-Singaporeans, so foreigners, or the protection of works of Singaporeans outside of the country, we have the international legal systems, which would be the Berne Convention for the protection of literary and artistic works, and the Agreement on Trade-Related Aspects of IP Rights, commonly known as TRIPS. Okay, so with this international agreements, a copyright work created by a Singapore citizen or resident is protected in many countries overseas, and generally under these agreements, the work of a Singapore citizen or resident will be protected in countries that signed these agreements as well. And vice versa, the works of citizens whose countries are members of these, the Berne Convention and TRIPS, would similarly have their works protected in Singapore as well.
Okay, the starting point is registration is not compulsory, but it's useful. The Chinese law said the purpose of a registration is to provide prima facie evidence in copyright disputes. So it's more like a recordal, formal recordal. So it's quite different from trademark or patent registration. So the purpose of that is it can confirm that you are the owner of the copyright if it's not challenged in future court. But the registration itself doesn't prove or confirm that you are the, whether you can be protected for your copyright or not under the Chinese law. You as the owner still have to prove the originality and the reproduction components at the court when there's a dispute. So usually the Chinese courts and Chinese authorities will accept copyright registration certificate as a proof of copyright ownership. And when you go to the court, it's quite useful to produce that certificate to say, I'm the owner of the copyright. Like Shamesh said before, that people didn't go ahead and have produce a document to show who's the owner of the copyright. So for that purpose, it's quite important to have the registration done. Now we're talking about the registration procedures. It is quite straightforward, quite different from trademark. Basically, you lodge the application documents, and the registration authority will review the application. And if you provide everything they're happy with it, they will issue the certificate within 30 working days. If some document missing, or they think that you have to go a bit further to produce the evidence, a document to show that you're actually the owner, they will give you 60 days to rectify the issues. And then once you provide the further documents, they will have another 30 working days to review and then issue the certificate at the end of the process. And this is no appeal process, because it's not really a registration as such. It's really just to record or formally record that you said you're the owner of the copyright. Now, one of those key documents when you apply for registration is the statement of ownership. You have to come up with something to say why you say you're the ownership, and that's really important. Without that, and I think the registration wouldn't go through. For that purpose, you need professional advice to prepare that document.
So in Malaysia, similarly in like China, registration is not compulsory, but of course it's a prima facie evidence also. It's called a voluntary notification process. The registration process is pretty straightforward. There are specific forms to enter, and there will be a declaration. And I think that is the most important piece of document, because it will consist of the date when the copyright is to be recognized, so to speak, and of course also the person who is applying, the applicant for the copyright, the identification of the person who's coming up with the artwork or so forth. So just like in China, it is just a prima facie evidence that you have actually registered, subject to challenge, always subjected to challenge in court. Parties vigorously contest copyrights in court from different angles, whether or not it's going to be registration or the content of the copyright per se. So yeah, so that's about all for the registration process in Malaysia.
So in India, there are a few stages for registration of copyright which are far simpler than the entire process for registration of trademark. So for instance, the original owner of the work could himself or herself file the application before the Copyright Office in New Delhi. It could either be done in his individual capacity, or it could be done through his attorney. There is a fee payable, and the application can be mailed to the office in New Delhi. There is an examination stage where after filing there is a 30-day waiting period for any objections that may be filed by third parties who may have a claim on that work. In case there is an objection, there could be a possibility of a personal hearing where the author would need to provide evidence to establish his or her claim in the work. If there is no claim, then the registrar would issue a copy of the entry made in the Registrar of Copyrights. Copyright registration, as I mentioned earlier, is not very common in India. Most authors or original creators prefer the route of establishing a date of creation by virtue of either self-mailing, creating an affidavit or declaration, or simply by putting a copyright statement on the piece of work. This is because of the common concern that people have is that once you file a work before the Copyright Office, there are concerns relating to confidentiality, integrity, and the possibility in the case of, especially in the case of software, source codes of reverse engineering or adaptation. So most people in India, most copyright owners prefer not to file for registration. They rely on the traditional methods of protection. And in some cases where there is, as I mentioned, a fundraise or a venture capital investment coming into the company that owns the IP, then there is a possibility that the owner would be advised to apply for copyright protection.
So as mentioned earlier, in Singapore, an author automatically enjoys copyright protection as soon as he or she creates and expresses his work in a tangible form. There is no need to file for registration to get copyright protection, and Singapore doesn't have a registration system. But there are some acts that an author is encouraged to take in order to prove two main things. One, that copyright exists, and two, the proof of originality. So when you want to prove that copyright exists, or rather you want to show that copyright exists, you could start off by clearly marking your copyright materials with the symbol C in the circle, which you're all very familiar with. So just to let you know, the symbol, right, the use of the symbol is simply a notice of a claim by the copyright owner that copyright exists. It does not give the copyright owner any substantive right and is therefore not crucial to the enjoyment of copyright protection. So even if you don't put in the notification or what we call the marking, it's not crucial. Okay, conversely, right, the non-use of the symbol does not imply that there is a waiver or loss of copyright. So what is the relevance then? So the relevance is that in an infringement proceeding, if an infringing party claims that he did not know that the copyright work was protected under copyright law, the court may take that into account and award lower damages. Right? So not having the marking, you might lose out in damages, although the court has found the party has infringed. So the use of the copyright symbol will generally stop the infringing party from successfully relying on such an argument. Then when it comes to proof of originality, we have a couple of things, three things that authors can do or copyright owners can use. One is deposit a copy of their work with their solicitors or a depository. Then send a copy of their work to themselves by posting or leaving the envelope unopened on its return, so keep it sealed, so that the date stamp and the unopened work would establish the date of existence and the work as it existed at the relevant time. So in Singapore, this is a very common practice where the work is sent back to yourselves and retained in a sealed envelope. And the third one, which is also very common here, is you make a declaration by way of a sworn statement stating that the facts of ownership and the date of creation, and you do this before a commissioner of oath, right? So there are no means or foolproof methods of proving authorship, as they do not prove that the work is original or created by the author. In a dispute, the court will still have to decide whether there is sufficient evidence to prove authorship.
Thank you everyone for watching our video. This is the end of our video on the protection of copyright in Asia. Our next video is going to be on the enforcement of protection of copyright works in Asia. Stay tuned.